Good evening. Well, it's been a while since I did one on time or regular Tuesday crime, Tuesday night crime. And here we are. And I've got three for you today. We've got both Bryan Kohberger, Lori Vallow Daybell, and Courtney Clenney. Now, we haven't talked about Courtney Clenney in a while. And actually, we haven't talked about Bryan Kohberger in a little bit either, because his hearings have been like monthly. We've been doing the hearing watch. The last one was so messed up, I didn't even record it, but I can get you all a link for it. Um, hey Pete, how you doing? Yeah, we got a lovely bunch of coconuts for you here tonight. You want to talk about Bryan Kohberger? Okay. Well, we can start with that one for sure. Bryan Kohberger, the big thing with that was the Dateline actual special that was released, and boy, did everything kick off from that. Apparently, there was information in there that both the defense and the state and even Judge Hippler are thinking were leaked. Things we've never heard before. I watched that Dateline special. Thank you very much, Pete. We did a viewing of it also. Some of us in the Discord. And there were so many things I did not know in there, like new things that had come out. There was some new interviews with people that know Bryan from the college, and talked about how kind of, you know, weird he was and stuff. There was stuff about searches, some rather strange searches that were done after, uh, in regards to Ted Bundy, you know. And what really struck me, I don't know about you, Pete, but how about that video of the white car the night of the murders? The night of the murders, coming back over and over again, and then pulling in, and must have parked near the home and was there for what, 14 minutes, and then tore out of there like a bat out of hell, all caught on someone's security cam. I had never seen that before. I had not. And that kind of struck me, like that was pretty damning. Okay. And then Dateline actually came out and said when Bryan Kohberger turned his phone off, which was like an hour or more than an hour before the incident. And oh, yeah, oh, and then he just turned it back on like a while after, and spent hours on the phone with his dad. Yep. Yeah. But his alibi is that he was just driving around at night. Because, when you're just driving around at night, mamby-pamby, you always need to turn your phone off. Because you don't need it for direction, or, to see what's open, or for any reason whatsoever. Not even to play, music in the car, whatever. You just turn it off. However, I'm pretty sure the prosecution, with the records from his phone, is going to be able to show that that's not a pattern. That it's not what he does every night when he goes out driving. Betcha. Betcha. That's why this is so upsetting. This is so upsetting to the defense. I mean, Ann Taylor is besides herself. She is besides herself with 40 pages of, we need to delay the trial, Judge. Judge, you're violating Bryan Kohberger's rights by not delaying the trial because I'm not ready. We need more time. Look at all this leaked evidence. We've got to find out who leaked this evidence, and then we need time to go after all of this. Well, you know what? It is evidence. So I'm sorry. What do you mean you need more time? You don't, because of this Dateline thing. And she said there's also new leaked evidence that's going to come out in a book in a couple of weeks. But my point is, It's not new to you, Ann Taylor. You know all this evidence because the prosecution needed to tell you about it. So you can't use this as a reason to delay the trial. Oh, but she's trying. And she was going to ask for a delay anyway. And she's putting all these citations in her 40-page pleading to the judge that, if you don't overturn it, you're like violating his rights because I'm not ready. And this is serious because it's a death penalty case. And oh, by the way, did you know, like, there's even like a part of it in there that she mentions that when the trials don't get the extension that the attorneys request, they get appealed and get new trials afterwards. They have a good reason for appeal. And I'm like, yeah, well, everybody on death row, if he gets convicted, if there's a death penalty verdict, he would get an appeal anyway. So, hey, whatever. Hey, Maggie. Hey, Mrs. C. Taylor already is a pain. She is. And that's why I wanted to. Okay. So that's why I got to honor my. Okay. So I should be putting this up here already. As you can hear, my voice is not doing great right now. So I apologize, everybody. I hope you can understand me. So we are going to talk about Bryan Kohberger. But man, we definitely are here to sing the praises of poor Judge Hippler. Okay, because Hippler, like, he's no nonsense. But he's really pissed. He sealed down this case on the information and somebody leaked information that was not out to the public already, and that's serious. And he said he's taking it personally, and he's going to find out who it is, and he's madder than a hornet about the whole thing, especially because he knew he was going to get a filing from Ann Taylor trying to delay the trial again. Now, this trial is supposed to go off in August, okay, and it's been delayed. It's been delayed over and over again. Now, he already extended it to August for Ann Taylor, and she's still not ready. And I don't think she's ever going to be ready. I really don't. Okay, they denied her on the death penalty. They denied her for all of these reasons. And she just needs to buckle down on the evidence. And I'm sorry, this is not new evidence to Ann Taylor or the prosecution. If they know it was leaked to Dateline and everything else, they know where it came from. It came right from their files. They've known all about it. That is not a reason. Why? Because we know about it now. How are we interfering with Ann Taylor being ready for her case? Are y'all emailing her and keeping her too busy? Y'all asking her too many questions? Y'all taking her out for dinner and lunches and stuff and keeping her too busy from getting down to the work of the trial? Like, what are you doing? I don't think so. Like, how does us knowing about this information that they already know about, how does that complicate her case? Is she refusing to even watch the footage of his car in the area? Because that's ridiculous. That is absolutely ridiculous. Is that true, Pete? Did she refuse this? I mean, that's ridiculous. That's a white Elantra. She better watch it. And plus, it was seen the very next day. Now, that video we knew about from way back in the beginning, where they said that they spotted that white Elantra near where the home is, where the murders occurred. And they had seen it around the time that morning after when everything was going on. There was also a picture I remember seeing with some trees, that you could look, and it was behind in the woods like there. She didn't care to watch it, huh? She don't care to watch. You know what? She better get one of her assistants on it, Pete. I'm telling you that. I don't want to hear this. She's not ready. I know she knows. I know she knows. There's a lot of evidence, okay? First of all, we do have the DNA on the sheet. I mean, juries love DNA. Am I wrong? No. Juries love DNA. DNA is, well, they were there. They touched something. They had something to do with it. They were there. When it comes to DNA, juries love it because it's like a no-brainer. Okay. It's like your fingerprint. It's unique to you. You were there. But then, like, now they've got travel times and everything of him possibly, getting rid of evidence, like where he went to get rid of it. And then there was these long calls with his dad, like if he was upset. And it what really, really got me. And I guess it's just the dramatization of it all. Cause you watch a Dateline special and they do it all drama, and they drop this and then they say all these like stuff and they make everything all sensationalized. But what they did do is when they said he was like after the murders, he took a very self-confident selfie picture in a mirror. And then he started watching the Ted Bundy stuff. And then he actually puts his hoodie on just like the Ted Bundy picture and takes another selfie, like with the hoodie like all towards his face and all, like the cover of Ted Bundy. Now I'm like, boy, is he associating or what? Like, what's going on here? I did fall for it. I was like, oh, look at that. Now that's not evidence, though. That's not evidence. I mean, they're gonna say, oh yeah, so he took a stupid photo. That don't make you a killer. Makes you a little weird. Makes you, gives the Dateline and all of us something to say about it, but it doesn't make you a murderer for sure. I wouldn't really call it good evidence, but I fell for it. I got all like, oh my gosh, look at that. You know? But I don't think that they'll be able to use that very effectively in the trial, to tell you the truth. Well, it worked pretty good for us, though. I'll tell you that. Well, there was a lot in there, and I understand why the court is all upset, but we're going to have another hearing on regards to this because, the judge is going to have to weigh in on this motion to delay for continuance. We're waiting to hear the state's response on that. I mean, she just filed this, I think it was on the 20th. And I have a copy of it if you guys, I'll just drop it in the chat if anybody wants to read it. It's like 40 pages. It's not really a lot that I would want to read. Like I said, she's just going on and on about how they need more time. And she goes on statute after statute, case after case, to where in the severity of the death penalty case and how you need more time and, average time that's spent in preparation. I mean, she spends more times researching all of these things to get out of going to trial than she actually is getting down on that evidence, But basically, the new release is not, if the information was leaked, it's a violation of protocol, and I'm sure the Judge Hippler is going to find out who it is, and they'll be sanctions. But in all reason to toss the case, because the people out here are not trying the case. They still will probably be able to get a non-partial jury. They already moved it. Remember, she got her change of venue. They're in Ada County now. Okay, they got moved out of Boise, and Judge John. He's not on there anymore. Now it's Judge Hippler in Ada County. That's where the trial's going to be. Everybody has to travel. The families have it the worst because some of the families can't afford to travel 300 miles to a trial every day, or to stay, at a place near where it's going to be Monday through Friday. And so there are some fundraisers going on. And I think it's mostly for Zana Canodal's mom. There's some people fundraising for her to have because she just doesn't have the funds. That is the motion for continuance file. If anybody wants to read it, but she's very wordy. She's no Jay Logson. He was at least entertaining a little bit. She's a bit dry in her filings. Anyway, so Judge Hippler is definitely going to try to find out who it is. We've already got a change of venue. Yeah, that has happened. Okay. I don't see this actually delaying it. Well, the state is going to have to file also, and we'll see. We'll see. One thing I did think of, though, with the popularity of this case and how serious this is, do you think they're going to bring in a special prosecutor? Now, they have brought in another person to help, Bill Thompson and everything, but they don't have a special prosecutor or anything like that. Do you think with the leak of the information that maybe they will turn it over to a special prosecutor? I'm wondering, you know. I just don't see him delaying it very long. If he delays it from August, I'm sure he's going to schedule it before the end of 2025. I can't see Judge Hippler wanting to hang on to this case. If you see this man's face whenever he has to actually do a hearing, and it goes on and on for hours. I mean, the last one I didn't record it. Law and Crime has a good copy of it. And hold on a second. I think I even have it here. Actually, here, let me give you the last Kohberger hearing if you want to watch it. There was a lot of breaks in it. And which was really driving me crazy. I may still record it for the file, but in the meantime, you guys can do it there, because I know it's a lot easier when we take out all those big, lengths of time in between and everything, when we could just fast forward and just get it all on file. Judge Hippler allows the recording of all the hearings through the Idaho website. You have to go right to his courtroom, and you can get a direct feed that way. I also saw a posting that Judge Hippler is going to allow the trial to be live streamed. I don't know if he's going to work on a delay or what, but he's definitely going to allow it to be live streamed. It was, Mrs. Cassandra, I agree. The Dateline was very damaging as far as public opinion. The way it was very slanted to make him look very, very guilty. It's like a hit piece, actually. Definitely. Well, that's what's going on with Bryan Kohberger. There's really not been a lot else. I mean, they're kind of going through evidentiary issues, and as far as stuff like that, Ann Taylor, she wants everything tossed. She wants the knife tossed. She wants the Google searches tossed. She wants the DNA tossed. She wants everything tossed. She tried to do it with going after all of the subpoenas and stuff like that, but that didn't fly. George has ruled on the majority of all of that, and just about everything staying in that I could see. I didn't see anything get tossed yet, but as soon as I hear anything, I would let you know. Now, Idaho uses the public site for these cases that are very popular. However, I got to warn you, most of it's sealed. Again, now it was sealed under Judge, for quite a while, the IgG testing arguments, all of that. So a lot of the information that we know about now, we didn't know about then, because Judge had actually, sealed it and kept everything pretty quiet. Now, it was open for a while with Judge Hippler. One of the first things he did was reverse that, and he didn't understand why everything was all clamped down. Well, now he knows why. Look, all these shenanigans. And so he clamped everything down a while back. That's why he is so upset that Dateline has this evidence that they have not talked about publicly, Mrs. Cassandra, I've heard a lot of people say this, actually. She says, I can see defense behind it to try to drag it out. Yeah, but like I was saying, how can they, when this new evidence, it's not really new. It's stuff they all know about. It's just new to all of us because we didn't hear about it. But there's no way that Ann Taylor didn't know about it, or the state. Like, it's in the evidence. It's in the evidence. It's in discovery. Hey, Liam, how you doing? Mippy, good to see you. Good to see you. All right. So we do love our Judge Hibbler, don't we, maybe? Like, this man is, well, he's all of us. If you ever watch him go to hit his head on the desk or hold himself up, like when she goes on the long arguments. And I think Ann Taylor is a fantastic lawyer. I do. She just goes on and on and on. She just wants her way. She really does. And she tried to wear this man down, but he's not having it, you know. I don't know. What do you guys think? Do you think he's going to issue the continuance because of this hubbub? Do you think he's mad enough to do that while investigating where the leak is from? And I wonder if the confidence in the law enforcement office over there with the prosecution, I wonder if it's waned, because he does think that it's coming from someone inside the case. But like Mrs. Cassandra, I think it's just as likely that it came from the defense. Victim rights, trial on time. That's what I say. He's got to balance it, right, Pete, between Bryan Kohberger's rights and the family and the victim's rights. Yeah. Yeah. I would say they've delayed it enough. They have definitely delayed it enough. But either way, I do hope that they will actually get it resolved before the end of this year. Hey, dog, welcome. Good to see you. Okay, so now we get to flip a coin for those of you in the chat who are here with the live stream. Who do you want to hear about now? Lori Vallow Daybell. Oh, I can't believe I'm talking about her again. Or Courtney Clenney. I'll give you a moment. Lori. Oh, so she'll said Lori. Anybody else got a vote? Daybell. Oh, it's Daybell. Sorry, Mippy. There's 4 Daybells there. 5 Daybells there. All right. So, okay, we're going to do her next. Let's get that ready. Okay, Lori. Oh, boy, oh, boy, oh, boy. Well, Lori Vallow Daybell. Well, you know, we got a verdict. We definitely got a verdict in our case against conspiracy to commit murder with her brother against her ex, Charles Vallow. And she was convicted. Okay, she's got it. We haven't had the sentencing yet, right? But we will. And she filed a motion to dismiss, but it was denied. And I think we talked about that. We talked about her filing it. Well, now we've got the motion to dismiss. And let me just pull that one up. And so Judge Barisky, what was the date of this? May 22nd. He filed that the court has received the following, remember he put out that notice about the juror statement and everything. And he did put that out. He put out that on May 1st, then the defendant filed for a new trial on May 1st, and that the state responded on May 2nd. And then the defense replied again to her on May 14th. And the court will address the issues in the order in which they appeared in the defendant's motion. So in regards to juror misconduct, he said the defendant alleges there was juror misconduct based on a statement juror 15 made to reporters following the verdict, wherein he stated, I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in prison in a cell. On its face, this statement would seem to indicate the juror violated the abomination in research the defendant, acquiring knowledge about her sentence imposed in another matter prior to the lifting of the abomination. However, the state's response included multiple additional media clips of statements June 15th. Juror 15 made both immediately prior to and after that statement, referencing herein above, in every one of which he specifically denies any knowledge of the defendant's other case sentence prior to the court, releasing the jurors from the admonition. Okay. At best, Juror 15 gave a single statement, which seems to be in conflict with all his other statements when he specifically denied any misconduct. Here, on the limited record of the pleadings before the court, there being no affidavits or sworn testimony evidencing any misconduct as contemplated by Rule 24, the court does not find a clear indication of juror misconduct, let alone any evidence of prejudice to the defendant. Juror misconduct requires a new trial only if the defendant shows actual prejudice, or if it can fairly be presumed from the facts. State v. Lear is what he cites. Okay. So he says, sorry, you weren't actually even prejudiced. If anything, he felt sorry for her, didn't he? I mean, he didn't say that, but that's what I'm saying. If anything, his statement made it look like he was leaning towards sympathy for her, and it would have been in her favor anyway. But that's not the thing. He denied it repeatedly before and afterward that he even knew. And he may have misspoke about how he feels so sorry for her based on the information he learned right after verdict. He said that everybody was Googling their phones and people were trying to get them to know the information almost immediately as soon as they were lifted from the sequester of information. So the judge goes on and he says, to address her other issue, the preclusion of Tylee Ryan and Alex Cox statements and impermissible testimony by Detective Daniel Coons. The court issued a preliminary pretrial ruling on March 11th of 2025, and we were all there watching it, regarding the inadmissibility of statements made by Tylee Ryan and Alex Cox. The court's ruling stated that out-of-court statements made by Tylee Ryan and Alex Cox appeared to be hearsay, and the defendant failed to establish that any specific statement was either non-hearsay or fell within an exception to the rule excluding the hearsay. The court went on to give the defendant the opportunity to offer specific statements at trial by stating the defendant could re-urge the issue outside the presence of the jury. Not only did the defendant never take the court up on its offer during trial, the defendant's motion for new trial in reply only argue in generalities, failing to set forth any specific statement that should have been admitted into evidence under either a non-hearsay exemption or an exception to the hearsay rule. As to Detective Coons' testimony, the defendant argues the detective did not have foundation to testify as an expert. Sufficient foundation was laid for the detective to give his opinion, and the defendant was offered no specific information as to what additional foundation should have been required. To the extent the defendant believed the witness was not qualified or his opinion should not be given weight by the jury, she had opportunity to cross-examine the witness about his qualifications or lack thereof, as well as the basis for his opinion. The defendant also argues that she did not have time to rebut Detective Coons' testimony. The record is clear that the defendant was offered more time to prepare for trial and declined. Moreover, the argument that the basis of Detective Coons' testimony was the walk-through of Alex Cox is not supported by the record. The defendant's reply for the first time raises the additional argument that Tylee Ryan's statements also formed the basis for Detective Coons' testimony. Again, there is no evidence of this, and the defendant offers no specific statement by Tylee or Alex to support her assertion. Even if what Alex Cox and or Tylee Ryan told Detective Coons somehow contributed to his opinion, the defendant never asked Detective those questions on cross. He never did anything Alex show you or tell you contribute to your opinion. This type of question would have been permissible. However, the defendant did not ask it, nor was she ever precluded from asking it. The court finds the statements of Tylee Ryan and Alex Cox were properly excluded, and the defendant has failed to raise a single specific statement that should have been permissibly allowed under the rules of evidence. Nor does this defendant establish Detective Coons' testimony was improper. And again, she goes on about the discovery violation, okay, in regards to the defendant's request for the additional discovery of Carlos Vallow's phone. She goes on again about them not having an original file to give her because it's so many years later, and they actually pull it by report, and that her expert was unable to pull the file adequately because the software has changed and it would be an updated version and not exactly what the state had pulled way back then. He finds, nope, there's nothing in the defendant's allegations that come close to establishing prosecutorial misconduct in regards to the discovery or for these reports from Charles Vallow's phone. Her expert had the phone and could do a download of his own. They were given every report that was pulled from that phone. They also could have subpoenaed the original expert to testify in regards to anything he may have saw, even though the original file wasn't included. But she didn't do any of that, nor did she cross on it very well in the trial. And he points that out. You know, the defense does not have to agree with the inferences and is permitted to argue the evidence and should it be interpreted differently. Okay. But she has absolutely no right of prosecutorial misconduct here because she did not do her due diligence nor on it. Okay. As far as the statement that he made since she was going down that line, he says that the RFRA, the Freedom of Religious Act, protects religious freedom and prohibits the government from substantially burdening a person's exercise of religion. But there is no conduct by either the state or the court that somehow infringed on defendant's freedom to practice her religion. Nor is there anything about the trial that impacts the defendant's freedom to believe whatever it is she chose to believe. Moreover, the RFRA does not protect someone from committing criminal acts in the name of religion, nor does the RFRA prevent any person from disagreeing with another person's belief. Here, different witnesses may have had different interpretations regarding who Nephi was or the significance of his story. The defendant had an opportunity to cross-examine those witnesses regarding the same. None of this infringes on the defendant's religious freedom. She actually tried to throw the Religious Freedom Act at them for this. For those reasons, the court finds again no prosecutorial misconduct. As far as attacking the judge personally, she's accusing the judge in her motion to dismiss of being partially and biased against her. And he answers that. The defendant alleges that the court was not impartial because the court struck two of the defendant's witnesses from the defendant's list. Contrary to the defendant's assertion that no rule of law or evidence requires her to establish a witness has relevant information, Arizona Rules of Evidence 601 and 602 require just that. Prior to trial, the defendant was given an opportunity to make a general offer of proof as to what relevant information the witnesses would provide, which the defendant was unable to provide and didn't. And we're talking about Nate Eaton and Brandon Bordeaux. When the court precluded those witnesses, the defendant was also advised by the court that during the course of the trial, if she believed these witnesses had relevant information, the court would revisit the issue. Thereafter, the defendant did not again offer any witness, even though she was specifically told she could re-urge the issue. In addition, in her motion for new trial, the defendant offers no further information on what testimony the witnesses would have given if they were permitted to be called. So you're saying that he was biased by not allowing it, but you're not showing the reasonableness why he should have, which you could have done at the time. And if you think was an error, you could be doing now. Well, she's still not. I mean, this is why you don't defend, you do not represent yourself, people, because you will be a lousy at it, a lousy lawyer, okay? The defendant also argues the court demonstrated a bias based on the court's comment made while overruling the state's objection during the defendant's questioning of Serena Sharp. The state was objecting to the relevance of the question, and the court thought the question had some minimal relevance based on the context of the defendant's line of questioning. The court notes the defendant's argument as to why the question was relevant was not in line with why the court surmised it was relevant. While the court's comment was not necessary, it does not evidence bias, nor does it mean the court was demonstrating any partiality. Nonetheless, court acknowledges the court's comment was unnecessary, and the court should have simply overruled the state's objections without comment. Moreover, the court has been presented no evidence whatsoever that this comment influenced the jurors. So that was when the state objected to Lori identifying something about Nephi and correcting them, and the judge said, "Well, if you want to associate yourself in that way, you're free to," or something of that nature. It wasn't really prejudicial. It probably was unnecessary. He should have just overruled the state's objection like he was going to, because he did. I said, but he did make a comment. And then she took it personally that showed bias, because she's just grabbing at straws here, as usual. Having carefully considered defendant's arguments, all of the briefing in the record, the court denies that the defendant did not receive a fair and impartial jury trial, and the defendant has failed to establish any ground for a new trial under AR Criminal R 24-1C. It is ordered denying the defendant's motion for a new trial that she filed on May 1st. And that's the end of that. Now, I'd like to tell you that that's where we leave it. But no. Now Lori is trying to get Brandon Bordeaux's trial dismissed. Now, May 29th, they start jury selection. May 29th. They will have a hearing of anything else that's left, which is probably going to be this motion to dismiss. Okay. And, well, hers is hard to read because hers is handwritten. It's very hard to read. It's very hard to read. Well, basically, she is, I'll just give you the nuts and bolts of it. She is definitely wanting a new, the motion to dismiss is based on the fact that the door and the window of Brandon Bordeaux's vehicle that was shot at, that had the bullets on it, was not preserved after all of this time for her to be able to have her defense, to have somebody examine it. She says that by not saving this type of evidence, basically they gave Brandon Bordeaux his vehicle back after a while, okay? And after they did all their testing and all on it. At the time that she was arrested and charged with all of this, had she had lawyers and decided, they could have done whatever, but a certain time has passed and it was not preserved the way Lori wants. So she says, so she can't look at it. It should be that there's only photographs and testing that was done at the time, and that is all she has, and she wants to do everything herself, and it should all be tossed out. Now, the state has gone against that vehemently, and we'll have to see on May 29th what Judge Barisky does. I don't actually see that Judge Barisky is going to do anything about it, because I'm sure that this issue came up during all the other hearings about the evidence, and I don't think this is the first time that he's heard it, although it's the first time I read it in a motion by Lori Vallow. So, well, I don't know. Are we going to be named in another conspiracy case? We may be. I mean, if she's after everybody who reports on it, I've been talking about her a lot. She wants Nate Eaton in there, although I doubt it. I really doubt it. I'm so small potatoes, but you all could be like, added to the list, for saying her name, She sure does annoy everybody, Mrs. Cassandra, and she's not a very good lawyer for herself. I mean, she has her issues and she just won't let them go. Point in reference, the last hearing that she did. You know, that was insane. Okay. That's this one, and she was snarky as hell. And I'll just give it to you guys if you haven't, or if anybody hasn't seen it yet. But we are supposed to remember, he said these issues could be brought up on the 29th. Anything that wasn't done. Now that's only like 2 days away, and we'll see. If there's a hearing, I will record it the best that I can, if I can. And get it out to you guys, and we'll talk about it the Tuesday after. But I'm not going to cover the jury selection, and we'll see about the court. I do believe the court is going to be live streamed. I do like Judge Boreski, but it doesn't look like Karen Reed is going to be ending anytime soon. Although things were quite exciting and not today. We had a very excellent witness when we did finally get to hear from him after delay after delay after delay all day. We spent more time looking at the fan than anything today. So then, tomorrow morning, he'll be back on the stand for the Commonwealth to finish. And then we go into cross-examination, and that's going to be by Robert Alessi. So I don't see it ending like in a short period of time at all. But we'll see, You know what, Mrs. Cassandra, I don't know why Lori Vallow is wasting Arizona's time on a new trial for Brandon Bardot. Like, she knows the evidence and how it went with the murder. Does she really think that she's going to not get conspiracy here again with Brandon Bardot? I don't know. We've got Alex Cox still involved. We got video of her preparing. I'm sure they have plenty of text messages back and forth about how awful Brandon was, and he was dark and all of that. And I don't know. Anyway, it's going to start jury selection on the 29th. The trial goes through the 13th, then takes a 10-day break because of things that Judge Boreski had on his trial calendar that he has to address, some kind of training thing. It starts again on the 23rd, 24th, and 25th of June, just in case those days are needed. The state had actually said they probably don't think they will go that well, but they did have some scheduling issues in regards to some of their witnesses. So they didn't think they could finish their case in chief by the Friday of one week, and they would have to go over the weekend and into that Monday, Yeah, I'm thinking it's like a day out for her, right? Liam says, I suppose that spending time in court means not spending that time in a cell. And I'm sure it feeds her ego too, because she has to deal with all these people. She's got a spotlight on her. She gets to deal with her advisory attorneys and her paralegal, and she's got her very own investigator, and it's like totally Lori Daybell style, right? She gets to order people around, and she gets to be the center of attention, and she's the big cheese, right? Except for she's like the smelly cheese, like Limburger. Yeah, Lori Limburger Daybell, the stinky cheese. Because, man, I can imagine, like, I don't think any lawyer wants to take this out. I don't know what's going on with her appeal for her Idaho conviction. But I'm sure that we're going to hear about that after the trials. They were still working on that. I don't even know if it's fully filed yet. I haven't seen it. I'll have to go and look. Why was she mentioned? Because of the change of venue, because of the popularity of her case in Idaho, and they proved that, like, it was hard, it was saturated, even in a town like Boise. And so they moved it to Ada County. They just mentioned it as a byline because of the change of venue issue. They did, but it had to do with the high profile cases. Yeah, something like that. All right, so the last one that I have for you tonight is Miss Courtney Clenney. Hold on. No. Let me. Oh, yeesh. Where did it go? Now, Courtney just had a. Some of you may have seen the hearing on my channel. She just had a hearing last Thursday. Now, what's going on with Courtney Clenney? She is the OnlyFans model who is charged with the murder of her boyfriend, Christian Obonsali. She says self-defense when she threw that knife from near the kitchen and it got into him and caused his death. He died later at the hospital. There was a whole big thing. Well, basically, what's going on with this is related to when her parents and she were charged with tampering with evidence and obstruction in regards to a laptop that they found in Courtney Clenney's apartment after it was released back to them after the investigators had done what they had to do and collected everything they wanted. So when they were packing up for her to move, because she wasn't going to stay there, her parents and her found the laptop, and they did turn it over to the state. But apparently there was discussions with her attorneys about it, and they tried to get into it. Courtney had the password because it was apparently a shared laptop. Either she bought it for Obsami or Obensali, or they both used it because she actually had the password for it and they got in. They didn't have to try to crack it. They just had to ask her. But they were trying to get into it beforehand. Which is, I mean, they're turning it over. It's going to be shared either way. But the state decided that that was shady business, and they charged them and they kept the laptop and they downloaded everything that was on the laptop. And when they did that, they got iCloud emails between the attorneys and Miss Clenney's parents, Kim and Deborah Clenney. And that the judge eventually determined was a violation of a time of attorney-client privilege, and the prosecution had no right to look at any of the emails between the attorneys and Deborah and Kim Clenney because they had hired them for representation and had talked to them about hiring for representation, and that they'd gone too far. Now, the prosecutor who admits to actually seeing one or two of these emails, Cahill Quinn, has actually stepped down from the case because also Judge Laura Sharon Cruz, she had actually ruled that he could be deposed and sworn for affidavit and couldn't be questioned on the stand in regards to what he read and how much information there was. So once that happened, in order to preserve the case, he stepped down, and the previous prosecutor who had stepped aside for Mr. Quinn to take over, Mr. Aberhoff, he came back. So Sean Aberhoff is back, and Miss Catherine Hogue, she's still there. But now, in this hearing, was about oral arguments for the motion that was brought by the defense to have the whole Miami-Dade prosecutor's office recused from this case because of the violation of attorney-client privilege in them doing prosecutorial misconduct, aka Cahill Quinn, ADA Cahill Quinn. Okay. That because he's still in the office, they could all talk. They still feel that they are at risk of this information getting out because just because, ADA Quinn's affidavit says that he did not share the information with anybody else. They have documentation that nobody else went into the files, and they have removed all the files from the system at the request of the judge way back. Still, it was orally argued that they still feel it's a risk and that they should not have the prosecution team from Miami-Dade County on this case. Now, that's going to delay this case if the judge actually agrees with them. Because Mr. Quinn still works in the same office with the other prosecuting attorneys. it's going to delay it because they're going to have to get another set of prosecutors on this. It is going to take them time to get up to speed, and it's going to delay things even more. At this point, we do not have a trial date still after all this time for Courtney Clenney. It's already been delayed over and over again. There's been multiple cancellations of the monthly hearings. They just keep getting moved mostly because of this. I mean, nothing has really happened except for this motion since the laptop thing happened, and then that case got dismissed. So it's just been going on. Like, this has been the issue for months now, back and forth. So it's kind of at a stalemate right now, and we'll have to wait. Judge Cruz did not make a order. She did not give an order at the time of the hearing at all. Like, she just didn't. I will say that let me just bring it up. Miss Clenney was not her gorgeous self. She seemed a little smug. There was some rather unflattering pictures of her making a terrible face with her attorney over some of the discussion that was going on. But basically, the prosecution says that they've solved the issue, that the prosecutors that are on the team now are professionals. They never looked at any of this stuff. They don't have access to it at all. And they even said that ADA Quinn doesn't even recall what he saw. Like, it's like nothing. Like, there's nothing to talk to him about. That he said in his affidavit to the court that he doesn't even recall the stuff that he read, and that the defense is making a big deal out of nothing. But the risk is there, and it is an issue. Attorney-client privilege is a big issue, and it's not to be violated. And so I don't know if Judge Cruz is going to err on the side of caution and actually give us a new set of prosecutors for this case. It would be extraordinary if she does, and it's definitely going to delay everything. But it seems like with this case, that's all we get is delays and delays and delays, Hey, Couch, how you doing? So, any questions in regards to Courtney Clenney? I have no new hearing date. We're waiting for a decision on this by the judge before anything else can be done anyway, because I don't think anybody's going to file anything not knowing which prosecution team would be dealing with anything. Like, why? Right? I think everybody's just waiting now. Now, they were scheduling monthly hearings. We'll see if there's one on for June. And if so, we will try to follow it. But I don't know. As soon as I hear about it, I'll be letting you know. Yep, she's sitting in jail waiting. So bad luck for her. You know what? All three of them, that's why I had let me go back. All three of the cases that I covered today, did you notice? Like, they're all behind bars. All of them. All three of them. Yep. Courtney could not get bail based on the fact that her OnlyFans career, she could have set up shop anywhere and got enough money to leave. Her father testified for her that, she, didn't have the funds to do it. He was in charge of stuff, but that didn't really fly. But the most damning information came from the medical examiner, who said he did not believe that knife could have been thrown from where she was and stuck in him the way it was. That she wasn't telling the truth, and that the wound was more up close and personal. And that really didn't sit well with the judge, that she might be lying about that, so she didn't get bail. Lori, well, she is in jail because of her Idaho convictions. She's not getting out. She got 3, now 4 life sentences, right? Mm-hmm. And Bryan Kohberger, he didn't get bail either because of the heinousness of the crime. There's great motivation for him to flee. It's not that he would be connected because of the penalty, and it's being a death penalty case. Of course he's not. Of course he's not going to get out in between, you know. But on that, that's my hour, and it was nice to spend it with you guys. But if you don't have any questions, I'm going to head out now. I'm going to go rest this voice and try to figure out what time we're starting court tomorrow for Karen Reed. And hopefully I'll see some of you there in the morning. Our next true crime will be Friday in the evening. I think closer to 9 o'clock. We'll be doing the weekly update on Sean Combs, P. Diddy's federal trial in New York, going over all the witnesses, the testimony, and all the happenings for the week, just to keep it up to date on that trial. Well, in the meantime, you know, we've got Lori Vallow in 2 days. We've got a hearing and some jury selection for the conspiracy of attempted murder of Brandon Bordeaux, her ex-nephew-in-law. And then we have to wait and hear about this motion on Bryan Kohberger for the delay of their August 11th trial. Yep. So still more to come on all of it. Keep checking the channel as these hearings come out, and as there's information, there'll be community posts and also short video for the hearings. Okay. I'll see you all later. And thank you. Thank you so much for joining me. Don't forget, like, share, subscribe, and please hit that comment section. I want to hear from you. Good, bad, or ugly. Talk to you later.